All right, welcome back. Okay, hope everyone's doing well. Any questions on your mind? Anything on your mind? Okay, if you notice, the readings today are kind of short. I think if I finish the readings in a timely fashion, we can actually do the review now instead of Saturday. I don't make any promises, but I think we can at least get the bulk of it done. In which case, you don't have to come on the weekend, and neither do I, which is not a bad thing. But I think we can do both today. So any questions in general? By the way, if you haven't picked up your exam, you can do it later. You should have done it, but if you haven't already, you can get it later. Cindy has them. She said 3 people picked them up, which is what I expected. This is why I'm not so keen to come here on Saturday either, because no one will show up. Exactly. Any questions in your mind? All right, let's do a poll question for today. Okay. I got to do this thing. I have start poll. Okay. They changed it. It's annoying. Okay, here's your question. True or false? If a buyer acquires a title with defects, the title cannot be marketable. True or false? That's your question. Maybe 20 seconds or so. Who was last class?
I'm first this time.
You're up, Aaron?
Mm-hmm.
Okay, Aaron, what do you think?
I think the better answer is false.
Okay, tell me why.
Because you can still buy a property that has defects. That doesn't mean that the title is not marketable.
Okay, so remind us, Aaron, what is marketable? How do we define a title that's marketable?
To make a title that's unmarketable, it's either someone owns the property, there's encumbrances, and...
The specific definition that the Kansas court gave in Lomar, it's a definition I like. Very, very simple. What renders a title unmarketable?
I don't know.
Andrew, you next or Marcos? Who's next?
No, it's to me, but I do not remember the specific definition.
Well, what were the facts in Lomar? Do you remember that much? That was the Kansas case, the second one we did on Monday.
This was the one about the doctor bought the one-story house?
Yeah.
Okay.
Good. That's right.
Oh, I found the definition.
Please.
That one. Okay.
With an assist from Erin, so she gets participation from credit calls over there.
A marketable title to real estate is one which is free from reasonable doubt, and a title is doubtful and unmarketable if it exposes the party holding it to the hazard of litigation. Very good. The last part is most important, right? A title is not marketable if it exposes the buyer to the hazards of litigation, right? The hazards of litigation. What does that mean? The day you own that property, you're walking into a lawsuit. The day you own that property, you're walking into an enforcement action by the government, right? So if a title has these sorts of litigation hazards, it's not marketable. However, I think Aaron made the correct point. If you disclose these errors and the buyer still goes ahead with the transaction, then it's his problem, right? Now, Miranda, why would someone buy a piece of property that has defects on the title? Why would anyone be that dumb to do?
Well, if they're doing it for money,
Bingo.
know about it, or if they're just going to clear it down.
Exactly. You can imagine that the purchase price for a property with defects is going to be a lot lower. And some people might say, look, I know maybe this house is not tall enough or too short or whatever. I'll demolish the house and build a new one. So there's nothing inherently wrong with buying
property with defects on it, there's no problem. One second. The problem arises if they're not disclosed. So the answer to this question is false. Aaron's correct on that one, right? See if most of you got this one. Okay, very good, Nate. 90%. Very good. So long as you disclose the defects, there is no problem whatsoever. Now, if you fail to disclose it, that's going to be what we're talking about today. Just both one distinction. The way I framed the question is talking about defects in the title. That is, someone else has a superior claim, you're in violation of a zoning law, you're in violation of a deed or covenant. This question is not asking about physical defects to land, right? A leaky roof, right? A cracked foundation, ghosts, right? No. This is asking about the defect in the title. So when I say defect in the title, what I'm talking about is like the risk of litigation, the definition Andrew gave a minute ago, right? So don't confuse like physical defects with defects of title. Marcella, patiently waiting.
So why would, like I was talking to my friend about this yesterday, and apparently they bought a lot that had like a lien on it, but everything was fine. Like they got.
Did they know about it up front?
No, they didn't. So they sued, like, because they got insurance from like a.
They got a title insurance policy. They didn't find the lien.
So how would that happen? And does that mean that the title isn't marketable, or that the deed is?
Well, Marcella, what's the difference between a deed and a title?
The title, like the deed is something that's a piece of paper.
Yeah, the deed is just the instrument, right? It's a piece of paper. So what you're actually asking about is the title. The deed doesn't really matter.
Okay.
So your question is, how did the title company not discover that there was a lien on the property? They screwed up, right? That's their job. They're supposed to find any sort of interest on the property. And if your family bought one, they should have had a title insurance policy. Did they get one?
Yeah, so they sued the insurance company, that company, and they sued everyone.
Did they get your family get your money back?
Yeah.
The full purchase price?
Mm-hmm.
That's right, they should. Right, I mean, when you have, I just went through this process, when you hire a title company, it's not cheap, it's a couple $1,000s. So you're paying them for their time to dig through old records and find any interest, whatever. And if they fail to disclose it, a lien or a mortgage or something, then they take care of it. It's unfortunate you have to sue them, though. They should have just done it on their own well-being.
Well, because they got a lawsuit from someone saying your property, like you have a lien on your property.
Oh, they tried to seize your parents' house and collect money on it. No, I mean, that's a problem. So the people selling it also did bad because they didn't disclose the lien as well. They concealed it. Okay, so one with me, right? Yeah, Mike and Andrew?
Is it the same as when people refer to a clouded title?
Exactly. If you say a cloud over title, what's a cloud? Something hovering over it. What that means is there's a superior interest hovering over your title. It's literally, that's the cloud suggests. Andrew?
I don't know. I just felt like I had a problem. I said true. I got it wrong. And I just.
Aaron's right.
I know. Well, what you're saying, I just had a problem with the call.
Yeah, this is like, is it always going to be defective, right? Just so, remember the phrase in these questions, right? It cannot be marketable. Well, it can be made marketable so long as you disclose the error.
So if someone else holds, like, claim to it.
Look, you can say, I have this piece of land, it's got a mortgage on it, I don't want to deal with it, I'll give it to you for $1. You deal with the problem. Okay. So you take the land for $1, and then you deal with the mortgage. Right? I mean, it happens.
Wouldn't they still
Yeah,
be
Bert?
exposed to litigation?
Yeah.
Absolutely. But you know it going in.
But that's not the definition.
If you disclose it, then it's marketable.
We need to do some more research.
Trust me on this one. Yeah.
Is that
Mike.
similar to assuming the risk by informed consent? Similar kind of
Something like
parallel?
that, yeah. It's not a risk of litigation if you know about it, right? If you know what you're getting into, you're fine.
Well,
Okay.
what I meant was, it doesn't mean that you can like go back on your contract because you didn't know about it. But by definition, it's not marketable.
If you know about it, it's marketable.
That doesn't mean you can't buy it, but I think I have the same problem as you.
Yeah, I'm telling you, that's not correct. Well, you're making valid points. You're making absolutely valid points. If it's disclosed, you can go ahead and have a marketable title and it can still be transferred. In other words, if a title's not marketable, it can't be transferred at all, right?
Why not?
You can't rescind a contract. Let me try it differently, right? If they didn't disclose that there was a violation of easement, you can move to rescind the contract because it's not marketable title. If they disclose it, then you can't rescind the contract because the title is marketable. They're one and the same.
Okay, I see where.
Is that better?
Yeah, yeah.
Better?
That
No. Don't worry about it.
Yeah,
I'll
come
do some.
on.
Okay, so
Jenica.
we said the definition was free from prospect litigation and free from reasonable
Hazard.
doubt.
Hazard.
Hazard, okay.
Which means the risk of it.
Okay, and then free from reasonable doubt. So is that it needs both of them, and that's why I mean, I get what you're saying, but I also get why they're kind of confused. But I get what you're saying, and I know that's correct.
Because he's the professor.
No, no.
I don't know if I can do much more than I've already said on this, so I'm going to move on, okay?
Okay, no. I was just wondering if it's because you need
Yeah.
both. Or-
Yeah, I think we've done enough on this. I mean, it's a risk of litigation. We disclosed the title's marketable.
I get that.
Okay.
Okay.
All right, let's move on. Thanks. Okay. I always appreciate spirited discussions, but we have to move along. So the topic for today is not about defects on a title. The topic today is about physical defects. Now, the traditional one is leaky roof, right? Cracked foundation, termites. Now, why do I mention those three things, a leaky roof, a cracked foundation, and termites? Because they're not obvious with a usual inspection, right? Often you don't know if there's a leaky roof until it rains. And often you can't tell if there's a crack in the foundation until the house falls, right? There are certain types of defects that are known as latent defects, right? L-A-T-E-N-T. Latent defects. Right? And the entirety of a latent defect is that it cannot be discovered with a normal, reasonable investigation. Right? So Madison, at common law, what was the rule about the disclosure of latent defects?
Are you referring to the doctrine of caveat emptor?
That's exactly what I'm asking about. Thank you so much. Tell me, Madison, what is caveat emptor?
It basically translates let the buyer beware, and it states that a maxim that a purchaser must judge, test, and examine the quantity of the item for himself. So basically, he has to discover possible issues himself.
Very
without
good.
The buyer informing him of them.
Very good, very good, very good. The doctrine at common law is a harsh one, and it's known as caveat emptor. That basically means, buyer, you're on your own. The seller has no duty whatsoever to disclose any defects. Okay? The seller is under no obligation to disclose any defects. Right? Now, what happens if the seller asks, hey, can you please discuss the condition of the roof? And the seller goes, roof is great, perfect, perfect. And it turns out to leaky roof. Okay. That's what's called a misrepresentation. Right? You can't lie about it because that's giving false info. But you can also sit there and stay quiet and say nothing. And there's a concept in the law which you may have come across in other classes. I don't know if you have. The difference between malfeasance and, I just thought of it, did I? Malfeasance. Malfeasance and non-feasance. Have you seen these concepts before?
Yeah.
Yeah? Shannon, do you remember this concept?
No.
Brittany, and I'll come back to Shannon.
Non-feasance is
Malfeasance is easier. What's malfeasance? What's mal? M-A-L. What does that prefix
Like
mean?
malice. So you're like if you're intending to
Do what?
do wrong to the person.
Do bad, right? Mal means bad, right? Malo, right? Malfeasance is when you actually do something bad. Okay? And then Brittany, what's the opposite of that?
You do something bad without knowing it.
No.
Possibly.
No. Anyone?
You don't do anything.
Say it louder.
when you fail to do something.
When you fail to do something, exactly. Right? Malfeasance is when you do something bad affirmatively, like you lie, you say there's no leak in the roof is fine. Nonfeasance is the opposite. It's like you sit there and you stay quiet. Don't say anything about the roof. You know the roof is no good, but you sit there and you stay quiet. Under the common law, malfeasance, prohibited. Under the common law, nonfeasance, it's fine. As long as you sit there and stay quiet and hope you don't get asked any questions, you could probably skate by. Lauren?
Well, which one would that fall under if someone asked you that question about the roof, like, any question like that? But instead of you answering the question, you just keep talking about whatever it is you're talking about.
You play dumb or you start to change the topic, you mean?
Yeah, like you don't even acknowledge that they asked that question.
Yeah, I mean, this is a very subtle line, right?
Mm-hmm.
And a lot of these cases are based on conversations that are not recorded. And if you ever try to recreate a conversation from memory, it's really hard. And he said, she said, all right?
Okay.
But, you can imagine, we're talking about the house, and Lauren says to me, how's the roof? It's a beautiful day outside. We'd like to go outside. Then you kind of change the topic. Was that malfeasance or nonfeasance? Probably not malfeasance. You're probably just playing dumb and say, let's change the topic, whatever, we'll talk about it later, and you never get back to it. So, I mean, this is why caveating towards a harsh doctrine. Because you have to basically cross-examine the seller. How is the roof? Tell me now. Give me an answer, yes or no. And if you don't do it, you don't pin the guy down. Right? This is why sales contracts are so long. This is why, for my friends who bought houses, you sign 1 million pieces of paper. Because it asks every conceivable question. What's the status of this? And what's the status of that? And what's the status of this? And the seller must affirmatively represent at each juncture what the status is. Right? There's no playing dumb. There's no staying quiet. You check off every box. And if you say the roof is fine on the contract, and it turns out the leaky roof, you've lied. That's malfeasance. Right? But not all land transactions use those long contracts. They probably should, but they don't always do it. And the two cases today are situations where they didn't use these sort of kitchen sink documents where they throw everything in there. Right? So the first case is a little bit weirder. The second case is more conventional. Let's see, the first case is more fun. I think one year I actually taught this case near Halloween. It almost quite worked out, but it doesn't always work out that way. But Shannon, you want to give me the facts, please? In the first case, I love this case: Stambovsky versus Ackley. The judge who wrote this is a man after my own heart with all these stupid puns. I mean, there's so many of them that I love it. Anyway, Shannon, give us the facts, please, in Stambovsky.
Okay, so the plaintiff contracted to buy a house from the defendant and then discovered that the house was haunted.
Mm-hmm. A little bit more.
And wanted to rescind the contract.
Okay. So let's just be very, I don't care if you actually believe in ghosts. It doesn't really matter for this class. But Cheyenne, for purposes of the court, how did the court say the house is haunted? Did they send the Ghostbusters or the Beetlejuice guy? How did they ascertain if a house is haunted? How did the court do it at least?
Well, the Supreme Court said that it wasn't. They said there wasn't any law to prove it.
Okay, and what did the Court of Appeals do?
Well, they said that since the defendant had talked about it being haunted and told people that it was haunted, that it was haunted.
Yeah, I think was the line, as a matter of law, right? My favorite line in the entire case. As a matter of law, the house is haunted. Now, you can say, what the hell, this is not law, but let's just go there for a minute, right? If the seller was willing to advertise the house is haunted to get, money for articles and tours and stuff, then it's almost like an estoppel, right? If you've taken a position, whether it's true or not, the court's going to hold you to that position. Okay. So the court said, as a matter of law, the house is haunted. Okay. Now, I actually pulled one of the articles by Mrs. Ackley, and I'll just read you an excerpt. She said that she was sitting in her living room one day, and then she saw a ghost floating in the air, rocking back and forth. Why? She was apparently painting the house, and the ghost approved of the colors she was using. Now, some of you are laughing, some of you aren't. I won't make any judgment based on that, okay? She said another one of the ghosts would dance, into her daughter's bedroom and would shake the bed and wake up her daughter. Then there was a third ghost, apparently, who was a Navy lieutenant during the American Revolution. Very specific. And my son saw him eyeball to eyeball. Ghosts have eyeballs. Did Casper have eyeballs? I don't even know. Eyeball to eyeball outside the basement door. Okay, so I won't do a poll on this one. Who here would, let's try it this way. Who here, if they found a house that was on sale for a really good price because it was haunted, would take the deal? Okay, so if you ask the other way, no one wants to raise their hand.
Yeah, if it was haunted, it was a good price and it was haunted?
Yeah, I don't care.
No.
Anthony. Okay. Okay. But that's the point, right? The fact that a house is haunted would decrease the price, not increase the price. And the seller knew that very well. So even though she's out here bragging to all the newspapers and all the magazines that the house is haunted, when she puts it on the market, oh, it's fine. And here's a picture of the house. I think it's in your book. It used to be pink. What? You like it? Yeah. But they painted it blue at some point. This is what Google has. You like the blue? Like better blue or pink?
Pink.
Like the pink better? It's less scary if it's pink, right? I don't know. Anyway, they painted the house blue. So the question here, right? The seller didn't disclose the fact that the house was haunted. Right? So Megan, under the doctrine of caveat emptor, could the buyer rescind the contract?
No,
That's correct. Why not?
because he bought it at his own risk.
Yeah,
He
literally.
bought it at his
Buyer beware, right? Yeah, exactly. You're welcome. So, but did the court, Megan, apply the straight-up doctrine of caveat emptor?
No.
Okay, tell me how it's modified here.
So they went through an analysis and determined there was an exception
Okay.
based on the confidential or fiduciary relationship.
Okay.
So they discussed a few other exceptions as well.
Okay.
Active concealment, affirmative misrep, partial disclosure,
Mm-hmm.
and where fairness and common sense dictate otherwise.
Okay, very good. Mike, let me ask you a question. Why do you think the court was so eager to carve out an exception to the doctrine of caveat emptor? I mean, they didn't have to. They could have just, this is an appellate intermediary court, right? Why were they so intent on doing this?
It's New York, so it's next to New Jersey.
Which one are you making fun of? This? New York? Give me an actual
Yes.
answer. Yes? No, not yes. What's the answer? Why do you think the court felt so? Why did the Spirit move them to modify the caveat emptor doctrine?
Because of fairness, they saw there was real financial harm done, even though because the value of the house was diminished by the reputation that it had.
But specifically, what about haunting was so unique that they felt compelled to, what was the phrase? Exercise in the body of legal precedent, right? Why do they feel so compelled to do this? The Spirit compelled them, right? Why?
Because they got to be the first to put their names on it.
Lauren?
Is it because no one could normally discover this?
Yes, exactly right. There's this one line, right? Who are you going to call, right? Can the Ghostbusters come and find this? Do you call the Terminex man, like an exterminator, to find haunting? I think the court was okay in crafting out this exception because it was so unique, right? This probably would not apply to any other defect. Maybe if that person was murdered in your house, someone died in that, I don't, there's some notes about that also, right? But I think the court was so compelled because we don't know. We can't know if a house is haunted until some revolutionary lieutenant shakes your kid's bed at night or whatever, right? So I think the court was okay in crafting out this exception because it can't be discovered. And this is very much a matter of fairness, right? if this woman was profiting off selling her ghost house, and she told everyone in the world about it, except for the person buying it, I think the court said that's not fair. And, you know, the F word, my favorite word, that I think led to his decision. So this case in New York didn't overturn caveat emptor, but I think it created like a ghost exception, basically, right? Where if there's haunting at hand, then the caveat emptor doctrine can apply because you can't find out a house is haunted. Will this precedent apply in any other situation? It's hard to think about it, right? I can't imagine how this could even extend to, you know, a leaky roof or termites or something, because even with a leaky roof, there are ways of testing it. You can figure that out in advance. All right, so any questions on the first one? I'll read all the puns to make you guys win some more. Phantasmal reputation, almost done. Ghost of a chance, spirit of equity, elusive if not ephemeral. He quoted Hamlet, of course. Who are you going to call? A hobgoblin which we exercise from the body of legal precedent and laid quietly to rest. Unearthly properties, ghoulish reputation. Okay, I'm done. Yes, Lauren.
Well, couldn't it be, what if something like, maybe they buried something or someone under the house?
Oh,
and
the cemetery.
Yeah, and they built on top of it, but you wouldn't really know until like maybe like months after or something like
Until
that.
rapture, or when would you figure?
No, I'm saying like if there was like an animal or something like that under the house and it wasn't stinking yet.
An animal buried.
Like or
Like a
something,
pet
like
cemetery.
something they buried under there and it didn't smell yet, so they wouldn't have found it out till after it started to stink.
So the objection is there might be a ghost dog of some sort?
No,
What- what's
but
that?
because of the smell.
Oh, the smell. Oh, I mean, ghost dog.
That's not something they would know unless they disclose
I
it.
suppose animals decompose pretty quickly. It's a couple days, right?
I don't know. I'm just saying, like, if somebody built a house.
It could be sub-zero
No,
weather.
I'm saying, like, if somebody built
mummy
a house
pad.
on top of something and they sold it to you right after they buried it.
Do
And
they
then
reserve
it
the
started
mineral
to
rights?
smell.
I mean, do they? No, I'm not trying to make light of your question, but if there's decomposition, that usually takes a fairly short period to decompose, and the closing period is probably longer than the decomposition period to acquire the house. Fair?
That's
Okay, that was usually then the remarkable question. Yeah, go ahead.
It kind of building off what Lauren was saying, but really on its own too. If it was the closing was in the midst of a long winter and the snow was built up sufficiently that it was actually hiding material defects,
All
whether
these
it
dead
was
bodies, just corpses everywhere.
Yes.
And until the summer, spring, and it melted, you didn't know the corpses were there.
it must be a George R. R. Martin thing.
Can I move on? Can I?
But if it was hiding something like a structural damage that really could not be detected, and because
Until the
of
snow melted.
Yeah.
And then it's concealment. Yeah, if there's like a mountain of snow on top of like a cracked foundation, you can't get there. I suppose that could be concealment. Kendra?
What if you didn't know about it, so therefore you didn't conceal it, but it's like a big thing?
You don't know about the ghosts?
Okay, I was thinking like the structure.
Well, if you don't know, right? If you don't know, then you don't know. And if you don't know, you can't be engaging in malfeasance.
But
Right?
you have to-
But the thing is, if this contract says, is there a leaky roof, and you check no, that's a problem because you had a duty at that point to say, all right, does my leak roof or not? Does my roof leak or not? Right? That's why those contracts are so long. They're designed to protect the seller as much as they protect the buyer, because it makes you have your own inspection before you sell the house. Anything else? Zombie dogs or cats? I think we asked me the zombie that came back to life. That's silly. Is there a question there? Anything else? All right, so the next case. All right, we had our fun. Next case is much more boring. It involves. Are you next?
No.
No, Audrey, it's going. You're right. It involves a leaky roof. All right, so you want to give me the facts, Audrey, please, in Johnson versus Florida, or Johnson versus Davis, from Florida.
Okay, so the Davisons entered into a contract with the Johnson Johnsons to buy a home for, I think it was like $300,000. And then the Johnsons knew that the roof had a leak, or was leaking, and said that, but they didn't tell the Davises about the problems with the roof. So then the Davises make a deposit, and the Johnsons leave the home. Then there's a heavy rain that comes, and water starts gushing out from like the windows and the ceiling. And then the Davises they bring an action to rescind the contract.
To rescind the contract, very good. Now, so one more to move on. Did the seller, did Johnson, lie about the roof?
I mean, I don't believe that the Davises asked them.
So they didn't ask.
Right.
So this is the case where they sort of just stayed quiet.
Right.
But do they know there were problems with the roof?
Yes.
Okay. So, Max, is this non-feasance, or is this an act of malfeasance?
The way they wrote it seems like misfeasance because they affirmatively represented that there were no problems with the roof.
They represented that there were no problems with the roof.
Right.
What do you think?
So I would say misfeasance.
Misfeasance, okay. The line's often very subtle, right? They knew the leak roofed, but they represented that there was nothing wrong with the roof. Were they actually asked, is there a leak in the roof? We don't know. So, I mean, let's just say this for a minute, right? If they ask you, how's the roof? Say, yeah, the roof's good. It works 364 days a year, but just when it rains, it's not so good. Am I lying? Because yeah, the roof's good. Right? Versus specific questions, are there any holes in the roof that could result in leaks? Oh. So you see the difference, right? If you ask a general, how's the roof? Oh yeah, the roof's fine. Everything's good. Is that actually malfeasance? I would be uncomfortable if I said, how's the roof? I'm needing to ask, is there any leaks, right? But unless you pin it with a precise question, it's not so clear. But I think Max has the right call. The court here thinks this is an act of malfeasance. But even if it was nonfeasance, right? It doesn't really matter in this case because they set a different rule. Michelle, what's the rule that the I keep saying it's basically New Jersey now, it's Florida, same thing. What's the rule that the Florida court sets here? What rule do they establish?
That the seller is liable to disclose any material defect.
What's the key word?
Material.
L.
L.
What begins with an L? What's the key word?
Validity.
That's the word, yeah. So we're talking about latent defects, right? If this is a defect that's obvious, there's a hole in the front door, okay, you don't need to disclose the fact there's a hole in the front door. But if there's a latent defect that's not easily discoverable, and it's material, the seller has a duty to disclose it. Right? This is basically nullifying the caveat emptor doctrine. Under caveat emptor, as long as you keep your mouth shut, you're fine, buyer beware. But the court says here, we're moving away from this doctrine. When I say we're moving away, you know where they're going, right? We're moving away from this doctrine. It's a harsh doctrine. And we're going to say if there's a material defect, there's an obligation to disclose. Now, Daniel, what does material mean? Michelle used this word a moment ago. What makes a fact material?
Well, I mean, with the leaky roof, it makes like the house kind of unlivable. It's just gonna.
But what's material? How do they describe this concept of material?
Like part of the main function of the house.
There's a concept. Lauren, how does the court understand the word material?
Like a structural issue.
Not just structural. So Gabe, what do you think? Material.
Affecting the value.
Yeah, there it is. It's got to affect the value, right? This can't be a trivial thing, right? It has to be material in that it has to affect the value of the property. Now, doesn't everything affect the value of the property by a penny or a dollar? So they don't actually give a definition of what is and is not material, right? They don't define it. But when you hear of material, it's got to be of some significance. It can't be a trivial impact. So you can imagine, I don't know, that one of the windows has some stain on the glass. It's a little dirty, right? Okay, is that material? Probably not. Maybe that the within the foundation there's a crack of like, you know, a little centimeter, which makes no difference whatsoever. Now that can have a big crack later, but if it's a small crack, is that material? Maybe, maybe not, right? But in this case, where the house is unlivable in a rainstorm, that's material value. I mean, I don't think anyone would dispute that. So the court holds that where the seller of a home knows of facts that materially affect the value of the property, which are not readily observable, and are not known to the buyer, the seller is under duty to disclose them to the buyer. It imposes an affirmative duty on the seller to disclose these sorts of facts. And the failure to disclose them allows for rescission of the property, of the title. Right, you can rescind it. Okay, so any questions in the majority of the opinion in Johnson? There are a couple of cases in the, what's that question? There are a couple of quick cases in the notes about cracks in ceilings and other sorts of things. One issue that comes up is that whether there's a duty to disclose that someone was murdered in a house, whether a house was formerly a burlesque house, a brothel. There's some cases about whether you have the duty to disclose if there are sex offenders living in the area. You have these registries. You may see Google an address and look where, see who's in the neighborhood. These issues also come up not just for the seller. Believe it or not, most of the times you buy property, you never meet the seller. Maybe meet them once or twice. You deal with the broker, right? And the broker is the agent of the seller. So if it's the broker that's failing to disclose stuff, and it's the broker that's perhaps lying about stuff, the same duties that are imposed on the seller are likewise imposed on the broker. So the broker has to affirmatively disclose any latent defects within his knowledge. Now, this is a situation that pops up. What if the seller knows about something bad but doesn't tell the broker? Oh. And the broker's like, yeah, the roof's fine. Broker's on the hook because that's the agent. And if he didn't do his due diligence to figure out whether the roof was actually fine, this is why you have these forms where the seller and the buyer make sure they do their own inspections, they do their own checks. Not perfect, but it makes things a little bit easier. Yeah.
So in any case, whatever, like if the broker is the one that's representing the seller and you never meet the seller, in any case, something that wasn't disclosed, even though the broker thought that it was fine based on what the seller told him, he's still liable just because he's an agent.
Well, it's his job. If he goes around making misrepresentations and he didn't do his homework, that's his problem.
So would you say for a broker, it would be, even though a seller told him something, it would be his due diligence to go back to double check what he said?
Yeah, and I suspect, has anyone ever sold a property or only bought? I haven't done the selling yet. Chelsea, you sold?
Yeah, we sold our family home.
Did you have to hire an inspection when you were selling it for the purpose of the broker?
We had appraisals on both sides, so you can take the value of the home.
Yeah.
And then that's how we found out about the foundation. And then
what was with the foundation?
there was an issue with it, and we had to fix it, and it increased the value of the property.
It increased the value because you put this new work into it. Was it expensive to fix?
Couple grand.
Okay. Yeah, so but before you put on the market, do your own inspection and get everything checked out. Yeah, and that's fairly common, right? In other words, if someone asks me, can you sell me this property? I'm going to do my inspection. If you ask a broker, can you sell this property for me? Also inspection. And, you have an independent inspector to hopefully check things out. Yeah, that's how things work. So any questions on that?
Is that also a protection for the seller?
Yeah.
So that if
Everyone.
the buyer, they can have someone say, oh, this is what's going on, this is what's going on, and they, kind of...
Yeah, I mean, this is the sort of dance you do, right? Where the buyer finds all these things that are wrong, and the seller's like, no, it's not a big deal. And you have this disconnect in the buyer and the seller. This always happens. Yeah, one other thing you can have is with home warranty insurance, where if there's some defects that arise within a year after you buy the house, the warranty company will cover it. I hope. Just found out my AC doesn't work as right. I thought it was, so now I got to deal with this now. right, any other questions on that? All right, let's talk about the exam from last semester. I think I covered everything. Any other questions on today's material? No? I think I can get this done in the next 40 minutes. Okay. So the exam, and I sent it to you last semester. If you don't have it, it's in your email. The exams are pretty good. I thought your curve was pretty strong. I don't know, no one failed, that was for sure. I think everyone did fairly well. Some high-level observations. A lot of you improved. And how do I know this? I go in and I compare your midterm scores to your final scores. I can do that fairly easily. And a number of you actually did jump up a bit. In particular, those who met with me more than once to do stuff improved their scores the most, which made me somewhat happy about this. In terms of the timing, I think just about everyone finished. I think only a handful of students ran to the clock. I can usually tell because number 5 is a lot shorter than number 1, and I can usually gauge this out. And I also noticed that most of you more or less followed my advice in that you kept 1, 2, 3, 4, 5 are roughly the same length, which tells me at least that you did it roughly the same amount of time. A couple students actually burned the word limit. That one, where are you going?
I have an appointment.
Appointment? What appointment?
Doctor appointment.
A couple students actually burned the word limit, and that's always surprising. I don't know why people would do that, but at this point, I use the word count feature. What I want to do with this review is not go over the nuances of property 1. I don't think you care about it. If you never hear of future interest again, you'll probably be happy, until the bar at least. But I wanted to just go through the general process of how I pose some of the questions and see if I can bridge a little bit of the gap to this semester. And if you have any specific questions, you can ask me now, and otherwise just come to my office hours. The Saturday thing, I don't think I need anymore because we finished fairly early today. If you want to come, I won't be here, but you're welcome to come on Saturday. So the first question is based on don't you see the Coco movie? Want to see it? Did anyone,
After the final, no, after the final.
did anyone not cry at the end? Yeah, it's a sad movie. I'm not going to ruin it, but I was crying at the end.
Yeah, you ruined it.
I ruined it.
You ruined it.
Remember me.
Like right after your final, like within a couple weeks.
Can't help you there. Okay. So let's just go through it a little bit, and I'll start. Make sense. One of the ways that I often do property exams, as you can probably tell, is I'll have the same fact pattern stretching both questions, and there's some pros and cons to that approach. The pro is you only have one set of facts to remember, but the con is it forces you to build up incrementally, and occasionally students try answering stuff in question number 2 in part 1 and vice versa. So be very careful to answer them in the order in which I give them, because that way you're staying on the right track. Okay. So the question was, Miguel is an only child, lives with Mother Coco in Texas. Every year they celebrate the Day of the Dead. They place the photographs on the altar, blah, 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 blah. And then they discuss this, right? And they find these conveyances in the back of the photograph. All right? What I always recommend that students do is to check each of the questions separately. Each of the questions separately. So read 1, 2, 3, 4, 5, and that helps you develop your outline. And one of the reasons why you should read each question at a time, not just start writing number 1, is I found a lot of students would answer question number 3 and question number 1, right? Because the questions overlap a little bit, they start answering the wrong question in the wrong place. And that doesn't get you credit, because I only grade 1 question at a time. So read each question at a time, then you can see in your outline what is and is not going to be sort of asked. Okay? that's another tip that I think was worthwhile. Okay. And in terms of the policy question at the end, I think more or less people got it pretty much correct. But these are always sort of bigger picture issues. And the distinction between the 6 and the 7s and the 8s and the 9s was how closely you could incorporate case law into your policy answers. Let me focus on number 5, because it's probably the one that you actually may have some semblance of a memory of what the policy is, right? Buried out of your head, everything else. So I have the memo here. So there were a lot of cases that discuss presumptions, but they're not going to be grouped into one logical category, right? The policy question is somewhat unique in that it stretches across the entire semester and picks bits and pieces from different elements. So when you are working on your policy question, it's almost like you have to have the syllabus in front of you, right? And run through the entire syllabus and check off almost every case to see, did this case have something related to that case have it? You can't get there unless you know the material well enough, right? You can't get there unless you have a very strong grasp of the entirety of the case law. Okay? So that's question number 1. What's the new question which you want to talk about? And I'm going to show you the midterm from property 2 last year, which I'll go over in a few minutes as well, which will be a little bit more helpful. What was the property one here? Oh yeah, this custom and traditions, right? You know, those sort of things come all the time, right? So, are there any specific questions? Again, I don't think you really care so much about the nuance of property 1 because you want to bury the nuance. Any specific questions you want me to go over? And if not, you can go office hours later. I don't want to bore you too much. Anything specifically on the 5 questions, on 1 or 2? No? All right. Let me pull up the midterm from last year, property 2 from last fall. And I want to just run you through it just to give you an idea of what we have ahead of you. Okay, property 2, fall 2017, exam, midterm. Okay. All right. So by the time we get to the midterm this semester, we will have covered almost everything involving land transactions, as well as some of the topics involving easements and covenants. We haven't gotten there quite yet. But the bigger difference between this year and last year is that there's a lot more modern doctrine. Last year, for the most part, I would say that 80% of everything was common law rule and maybe 20% modern rule. This semester is a lot more modern stuff. It might be 50-50. So you're going to have a stronger grasp of when you're applying common law rules and when you're applying modern rules. Because even with something like adverse possession, right? You have the different states of mind. Some states have the aggressive the hostile aggressive standard. Some states have the objective standard. Some states have a good faith standard. So in the same topic, you might have 3 different standards. So that's why this semester is a little bit more tricky in that the same topic, depending which court you're applying in, can have different regimes. I don't think it happened on this midterm, but you'll have to be much more attuned to the fact that you're talking about specific aspects of jurisdictional law. So I'll say you're in New Jersey, you're in Pennsylvania, you're in Texas. Those sorts of things actually make much more of a difference. Okay, why is that not working? Sorry, I opened the wrong file. That's not working for some reason. Yeah, it was the wrong one. Classes, property 2, okay. Midterm. opening. I don't know, I can't find it. All right, find another one. Oh, this is very strange. It's not working as I planned. What? I'm sorry, you should have the stuff ready. It's not. I opened the wrong file in advance. All right, I'll just have to wing this one. Sorry, I thought I had the file. It's going to take me long to find now. So at least for the midterm in this class, you'll have to pay very close attention to how different jurisdictions vary in the law. As well, there are certain transactional questions. The sequencing of events actually matters quite a bit. So you'll have questions where person A sells a property, then person B does this, and person C does that. So having each of the various aspects of the transaction structured, I think, will help you significantly. Okay? All right. Any general questions on this? Not working as well as I thought. Yeah, Brittany?
Are there answers for this past midterm? I haven't looked at it, so.
Yeah. So
if it's clear on it, but I know you said that you began to prepare the answers not from just one person.
Yeah. Let me talk about it. So I circulated over the summer 2 documents. I circulated a memo, which is like 9 pages long, which explains my thinking, and I created a hybrid A+ answer. So there are pros and cons to hybrid A+. The pro is I took all the top 10s. Basically, whoever got the highest, like the 10, I just put all those into one question. The con is it exceeds 1,000 words. And the reason why is people allocate their time differently. So some people might put 300 words in question 1 and got a 10, and 100 words in question 2 and only got 7. So I picked the top 10s. So the hybrid answer there will actually be longer than 1,000 words, but it's a stronger representation of the best answer.
I'm talking about for property 2.
I did not do that for property 2 last year. No, I'm sorry.
So anything that we're going to look at for property 2, those are all actual A+ answers.
Those are actually plus answers, which might not be perfect. Yeah.
Okay, that was my question.
Yeah.
Thank you.
Yeah, it's. I only thought of this last year, and it didn't always work out.
Thank you.
My pleasure. All right. Anything else in your minds? Yeah, Megan.
Is the exam going to be open notes again?
Yeah, same as last year, same as everything. It's almost it's going to be the exact same experience. This is why this is a little easier than I thought it would be. It'll be the same experience. Everything curves out though. The curve, if you look at the actual GPA distribution, is actually fairly high. I don't always do that, but your section is pretty strong. So even if you suffer, you generally end up in a higher place. Anything else you want to ask? Anthony?
Yes. On one, specifically looking at the question 1 and 2, what was your thinking on the answer that would have been along the lines of what you would have been looking on in the rest of the final exam?
Which question are you asking specifically?
Specifically on part 1, question, I want to say question 2. I was thinking 1, 2, but I was thinking, I think it's just more question 2 on part 1.
So part 1, question 2, let's see what I wrote. All right. Oh, I remember this one. Okay, I'll go over this one if you want. So this one was about a conveyance. What's that?
Nothing.
Do you not want me to do this?
No, you go ahead.
Okay. Sure, it's fine?
You go ahead.
Okay, thank you. With your permission, yes. So it says, the second conveyance states, I, Hector, give all the intellectual property associated with this song, Remember Me, to Ernesto. But if Ernesto does not credit Hector with writing the lyrics to Hector for the rest of his life. And the movie was about the movie was actually about intellectual property, which is why I wrote the exam. It was about the rights to a song called Remember Me. And so 1 year after the conveyance was drafted, Ernesto released his recording, Remember Me, and he didn't credit Hector, which is a violation of the conditions. So it says, identify all the present and future interests for the IP associated with Remember Me at the time the conveyance was drafted, and after the release of the recording, who owns it. I often do this where, instead of just saying what are the interests, I'll split up in 2 different times, right? this is a formatting issue, makes my life easier. If a question has two parts, A and B, then your answer should have two parts, A and B, and actually label them A and B, because that makes my life a lot easier. If it's not obvious, it's generally 5 points and 5 points, right? If I have two parts, it's 5 and 5. If there's 3, it's like 3 and a third, and it's not perfect. But I generally try and do 2, which makes my life a little bit easier. So if you answer the first part perfectly, you get 5 points. If you leave the second part blank, you get 0 points, which is actually what a lot of students lost off credit on because they only answered half the question. But in the memo, let's see what I wrote. Okay, I don't remember exactly what I wrote, but in the memo, all right. Okay. All right, let's read it. I'll just read it because I reviewed this one carefully. It says, Hector gave Ernesto a present interest in the IP for the song, and to determine what kind of interest was transferred, we just study who has a future interest. Okay, blah, blah, blah. Okay, and the correct answer there was that Ernesto was a fee simple, subject to subsequent, and Hector has a right of entry. Okay? But one of the wrinkles was the conveyance didn't specify who had the remainder. And this is why the question was very difficult to answer. Every now and then I'll ask a question where there's not really an obvious answer because I haven't given you all the information. And several of the top students actually noticed that and said, we don't have enough information to recognize this. So just keep that in mind, right? The best answer might be, we can't answer this question. It's somewhat of a wrinkle, but very often the law isn't entirely clear, but not always perfectly. Okay? All right, answer your question? All right. What else? All right, if you have anything else, you can come talk to me. I'll see you guys later.
I'm sorry? Are you talking about the marketable one?
Yes.